Hi, everyone. I handed in a provisional patent application, for which I paid the $60, which was required to file at the USPTO. 2 weeks later, I got a note from the USPTO with a notice to file missing parts of a provisional application. And it says I need to pay an additional $300. So apparently the $60 counts as a surcharge for late submission. If anyone knows if this is correct or has an explanation, much be appreciated. Okay. Well, and so, being right up front, I haven't filed an application in a while myself. We have a paralegal team that does that. I will say the notice is usually pretty clear in terms of what is missing, hopefully. Usually when you submit an application for a provisional patent application, it is far less rigorous than a non-provisional. A provisional must have a specification and a cover sheet. And then I think a fee. David, I don't know if you have anything else. It's not much, and figures as needed. They're not required. Usually it's a good idea. So the specification is a fancy word for a written description of your invention. And, the goal there with the provisional even is to make sure that your invention is fully enabled. So you want to make sure it's written not just high level, but really laid out so that someone could go make it and use it. A lot of inventors make that problem, I should say, when filing on their own, is they're just not as detailed, and they usually don't cover a lot of applications or versions or other embodiments of what their invention could look like. So it's really just kind of this one narrow invention of what they've built, perhaps, or what they see as going to market. And really, a proper provisional should be very fleshed out, covered in a lot of different aspects. Without going too much further on that angle, I think that's it. It says a spec, drawings, and a cover sheet with payment. So, David, do you have anything else you might?
Just a practical bit, which is as soon as you've put something into the USPTO and your contact information is on it, you will be contacted. Not necessarily by the USPTO and not necessarily by people who care if you know that they are or not. So it's the ones that look really real are the ones that we need to be the most concerned about. The ones that are clearly phishing or spear phishing or whatever you want to say. Right. Those are easy to sidestep, not a problem, right? It was drawn in crayon. I'm just saying, just because it looks like it came from the USPTO, do what you can to make sure that that's a legit communication. When somebody's saying, oh, you need to give us $300 more, actually the USPTO usually says what you've done is insufficient, bam.
Yeah.
They're not going to tell you what to do about it. So I get suspicious immediately when it says, hey, just pay us another $300 and you're good to go.
I agree. Really? That's a great point. There's a lot of fraud. Matt mentions it more on the trademark side.
It's constant.
Gosh, it's just awful. The Bureau of Trademarks, right? No, there's just one. Make sure it's a government entity. I believe these marketing companies, they're required to have a statement that says we're not affiliated with a government institution. You got to read the fine print. Gosh, they look official. They all kinds of QR code scanners. You've got to read through it. One great way to avoid all that is just hiring counsel and just get it done right.
Yeah.